Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is What's Happening in Hong Kong, the Philippines, and Japan? Catching up with international enforcers at the 2025 Spring Meeting. The Antitrust Law Section's annual Spring Meeting in Washington, D.C. is the premier opportunity for practitioners, government enforcers, economists, and in-house counsel from around the world to exchange ideas about competition, consumer protection, and data privacy law and policy. During this year's meeting, the Our Curious Amalgam team recorded interviews with senior competition agency enforcers from Hong Kong, the Philippines, and Japan. In the first segment of this episode, Anora Wang speaks with Ellie Siu, Senior Legal Counsel of the Competition Commission of Hong Kong. After that, Matthew Hall interviews Michael Aguinaldo, the Chairperson of the Philippine Competition Commission. And finally, Commissioner Reiko Aoki of the Japan Fair Trade Commission, who was featured in our 2024 International Enforcer Series, returns to the podcast to speak with Anora Wang. You'll hear what's been happening in their respective agencies, as well as a little bit about what makes them happy outside of competition law. Enjoy the conversations.
Hello and welcome to Our Curious Amalgam. I'm your host, Anora Wang. Previously at OCA and about a year ago in April 2024, we learned a bit about Hong Kong Competition Commission, or HKCC, and its entrepreneurial approach to enforcement. Today, we get to speak with an enforcer from HKCC again and get an update about the agency's major enforcement activities in the recent past and near future. Joining me today is Ellie Siu, Senior Legal Counsel who has been with HKCC since December 2023. Ellie is an experienced litigation and regulatory lawyer, having worked as a dispute resolution lawyer at major international law firms and as in-house lawyer at leading multinational companies. Ellie holds a Bachelor of Laws degree from the University of Hong Kong and dual Master of Laws degree from New York University and National University of Singapore. She is a qualified solicitor in Hong Kong and England and Wales and is admitted to New York Bar. She's very impressive, and welcome to the OCA podcast, Ellie.
Hi, Anora. Thank you for having me.
A pleasure, Ellie. To start off, could you please just remind us of your agency's missions and what it did in the past year, very briefly?
Sure. So by way of brief introduction, the Hong Kong Competition Commission was established in 2013 under the Competition Ordinance, which was enacted in June 2012 and came into full force in December 2015. So we're actually celebrating the 10th anniversary of the Competition Ordinance coming into full force this year. So the Competition Commission is an independent statutory body, and our functions include to investigate conduct that may contravene the competition rules, to enforce the provisions of the ordinance, including to bring proceedings before the competition tribunal against undertakings who have contravened the ordinance. Also, we also promote public awareness of competition law in Hong Kong, in particular given competition law is still in its early development in Hong Kong. So the objective of the ordinance is to prohibit conduct that prevents, restricts, or distorts competition in Hong Kong. Our substantive competition law is largely modeled on EU law, and our competition ordinance is similar to the TFEU with 3 pillars. First is the first conduct rule, which concerns agreements and concerted practices that have the object or effect of harming competition in Hong Kong. Then we have the second conduct rule, which prohibits those with substantial market power from abusing their power by engaging in conduct that has the object or effect of harming competition in Hong Kong. And thirdly, we also have a merger rule, but currently it only applies to mergers in the telecommunications sector.
And would you please also tell us What's the major enforcement activities that has been conducted by HKCC in the past year or so?
Sure. So in terms of what we did last year, it has been a very busy year for the Commission.
We're speaking of 2024.
2024, yes. In terms of both enforcement work and actually non-enforcement work as well. So if we start with enforcement work, the Commission had 4 full-on trials before the Competition Tribunal in 2024. And each of these 4 cases involves unprecedented legal principles being put to the Competition Tribunal for its determination, which will set important precedents for Hong Kong jurisprudence. I should also mention that one of these cases is actually in 2025, so it's still within the last year period. One of these cases is the Commission's first case on abuse of dominance, and another is the Commission's first case on resale price maintenance, and we are currently waiting for the judgment for these 4 trials. And in addition to trials, we also was able to settle with respondents before going to trial. And one of these cases involved 2 companies providing cleaning services to estates managed by the Housing Authority in Hong Kong. And the companies admitted to exchanging price-sensitive information when bidding for the service contracts, which amounted to price fixing. And the Commission secured a total of over 22 million Hong Kong dollars, which is around $2.8 million US dollars, and penalties being imposed against the relevant companies and individuals. And also director disqualification orders are made against the directors of these companies. To note is that in this case, we also managed to secure our first criminal conviction against an individual who was caught deleting relevant documents during the course of our dawn raid, which resulted...
not because of conducting the price fixing, but preserving the documents.
Yeah, it's an obstruction of a dawn raid.
Who is like an employee of the company or not, or legal counsel?
Yes, employee of the company.
I see.
And so this resulted in a 2 months imprisonment for that individual. The individual is currently seeking the appeal of the conviction.
I see.
So other than the enforcement side, proceeding side, the Commission also had a busy in terms of its investigation. We conducted quite a number of dawn raids, some of which were joint operations with other local enforcement agencies. And last but not least, I also want to mention the non-enforcement initiative last year, including a successful international conference called the Competition Exchange, which was held just last month in celebration of the 10th anniversary of the competition law enforcement in Hong Kong.
So that's March 2025.
Yes, correct. So it was attended by close to 400 participants from all around the world to exchange perspectives and insights. And we had over 30 speakers from 14 jurisdictions, including judges, law enforcers, and leading experts in the field to share their experience.
That's very interesting. So what is your organization's top enforcement priority looking forward for a year or so? So we're talking about 2025 through early 2026.
So it is expected that the Commission will continue to focus our investigations and enforcement actions on 3 key areas. The first one being anti-competitive conduct affecting livelihood issues. So we believe that anti-competitive behavior which affects people's livelihood, especially those of low income or grassroots groups, are appalling and deserves our attention. So, for instance, one of the trials in 2024 involved sales of textbooks to local students. The Commission's case is that these textbook retailers, they agreed on the discounts that they would give to primary and secondary schools on textbooks in their bid submissions, so as to ensure that the incumbent textbook retailers would win the bid, and therefore contravening the first conduct rule by engaging in price fixing, market sharing, and bid rigging. We are waiting for judgment for this case, but I guess you would agree with me that these students are least able to afford paying cartelized prices. And the second key area is cartels that aim to exploit government or public funding. Cartel is that increases the price that government pays for goods and services, are enriching themselves at the expense of the people. And so this should be penalized, and investigation of such conduct should be prioritized. And this involves 2 potential situations. One is cartels that target government departments or public bodies which directly procure goods and services. The case I just mentioned about cleaning services provided to the Housing Authority in Hong Kong, which was resolved by way of settlement, is a very good example. And the second potential situation is cartels that target procurement of goods and services by businesses under government funding or subsidy schemes. In 2024, the Commission received the Tribunal's judgment in its first cartel case relating to government subsidy scheme. And this case actually also involved the Tribunal's first default judgment against the respondent who failed to file a response. And last but not least, the third key area is conduct impacting digital markets. So it is expected that the Commission's case mix will be similar, and that is we will continue to investigate both cartel conduct and abuse of market power and more complex forms of anti-competitive conduct. I should also mention that the Commission has been making a great deal of effort in fostering strategic partnerships with competition authorities in other jurisdictions, and with a view to enabling us to leverage their experience and resources when carrying out our enforcement duties. And the Commission will continue with such effort. And talking about cooperation locally, the Commission will also continue its cooperation with local Hong Kong law enforcement agencies such as the police and the ICAC, which is the Independent Commission Against Corruption, responsible for combating corruption in Hong Kong. Such cooperation is particularly important for a commission, as being a relatively small agency. It is very helpful to be able to tap on the resources of other law enforcement agencies.
And these are mostly for down rates?
Yes, so dawn rates and mainly for dawn rates, yes. And I mean, there, I can give you some examples. There are two circumstances where we seek such assistance. So one is where there are matters of concurrent jurisdiction. So as I suspect it's similar in any other jurisdictions, cartelists are not always specialists. So they take a generalist approach in laws that they are willing to break.
Right.
So therefore, there will be situations where a case does not only involve anti-competitive conduct, but also involve criminal elements. So by way of example, the Commission and the ICAC conducted their first joint operation last year regarding a newly rising syndicate engaging in corruption and tender rigging in relation to building maintenance. The other circumstance is where the matter is solely competition related, but one where the Commission is seeking assistance from other agencies. So for instance, the presence of the police when the Commission executes its search warrants allows us to conduct a more effective dawn raid.
That's very helpful. That's a lot to look forward to. I guess maybe next year we can get another update from you. Yep. And then maybe some interesting and success results to hear about.
Yeah.
While you were with us, we will also want to get you insight into maybe your observation and thinking. So what is the most important trend that you see developing in competition law enforcement in the near term?
Right. I mean, there's no doubt that much of the discussion in the international competition community relates to AI and digital markets. I mean, we have seen very large fines by the European Commission, upheld by the European Court, and there have been also developments in relation to Digital Market Act in the UK and other legislative attempts to address competition and other issues in the digital economy. And as mentioned, conduct impacting the digital market is one of the three key areas the Commission has been and will continue to focus on in terms of our investigations and enforcement actions. So by way of example, the Commission has addressed concerns over two major food delivery platforms in Hong Kong by way of commitment, which resulted in amendments to the food delivery platforms' respective agreements with their partnering restaurants and removing exclusivity clauses and price parity clauses. So I think Hong Kong is unique in that nowhere else in the world you have Western tech giants that battle with Chinese tech giants head-to-head alongside local players in such a free manner. This means that whenever the Commission is asked to look into a particular matter involving a digital market, one of the questions we have to ask is how relevant is overseas experience and jurisprudence to Hong Kong? I think the presence of overseas services in Hong Kong obviously benefits competition and dynamism, but that may also kind of complicate any competition enforcement action. But the Commission has worked closely with our counterparts in other jurisdictions, and our ordinance provides clearly that conduct which impacts Hong Kong, even if it takes place beyond our border, is still captured by our competition law. So the Commission will continue to engage in active monitoring in this digital sector.
And I think you mentioned in merger enforcement, HKCC is limited. Is it by law or by decision that it only would enforce when it relates to telecommunication? right?
Yes. So this is by law that the current merger rule only applies to telecommunication sectors.
So the enforcement that you just talked about in relation to digital, they're all in the conduct area.
Yes, correct.
Non-merger. And you don't see, you don't foresee a change to the law in terms of merger enforcement, right? With all the things developing in the world and all the focus on digital.
The Commission is constantly looking into this area and will constantly evaluate the situation and see when and as necessary that a merger rule, a cross-sector merger rule is necessary.
As an enforcer, you do see practitioners come before you from time to time, or maybe all the time. And what advice would you have for practitioners who want to be effective in front of you and or your organization?
Yeah, so first thing to note is we have a very comprehensive and transparent leniency policy, and companies should make use of it. So it provides complete immunity, including from follow-on private damage action, for the first party to report the cartel conduct, which we were not previously aware of. So if your client has any concern about being involved in a cartel, we would strongly encourage you to contact the Commission about leniency. And even in a situation where you may not be able to benefit from the leniency policy because someone has already obtained leniency or because the company is too late to provide substantial assistance to the Commission, the Commission has also a very comprehensive and transparent cooperation policy by which the companies involved may obtain reduction in pecuniary penalty and other reliefs if it admits liability and cooperates with the Commission in terms of its investigation and subsequent enforcement proceedings. So we are keen to receive complaints from market players about any potential anti-competitive conduct, and the Commission will seek to protect any confidential information provided, including the identity of the informants, in accordance with the ordinance and the Commission's guidelines on investigations. And information provided anonymously will also be considered by the Commission. And last but not least, the Commission has published clear guidelines regarding our law, including, investigatory powers, leniency, and cooperation. But while our competition law regime looks to the EU regime, there could be instances where how it operates is slightly different. So practitioners should not assume the EU regime will apply exactly the same in Hong Kong.
I see. Is there a hotline that people call and their counsel call?
Yes, there is. So it is clearly mentioned on our website. And if anybody is interested, they could.
And on that call, would they know whether they are the first person to inform you?
So in terms of the leniency application process, the first stage is actually to obtain a marker. So by calling us, we'll then decide whether to grant a marker to the applicant. And by granting a marker, that means you are the first one.
I see. So that's a little bit of similar to the practice here in the U.S.
Yes, correct.
We don't have too much time, but we do want to learn about you personally a little bit better. So do you have any interesting hobbies or accomplishments? Anything that people would not usually know you if they had just worked with you?
Right. Probably not accomplishment, but I do, enjoy music, both listening to it and playing it. So I would play the violin and piano during my leisure time, and I think playing the music allows me to, wind down, and it's a good way, effective way to recharge and, to relax outside of work.
I have to ask, and maybe I because I'm Asian, you're Asian, and then I maybe ask this a little bit without filter. Were you forced to learn the violin and piano when you were little, or did you actually pick them up naturally?
Well, I would say when I was really young, it's probably partly forced, but I'm very grateful for the opportunities and now that I'm able to play those music instruments, because I wouldn't have been able to play it if I haven't started early.
All right. Yeah, we're all grateful for our parents for their pushing in our growth.
Correct.
Thank you so much for spending time with us.
My pleasure.
Hello, I'm Matthew Hall, and I'm with Mike Aguinaldo, Chairperson of the Philippine Competition Commission, or PCC. He is the second chairperson since the establishment of the PCC in 2016. Mike is a lawyer and worked in the private sector before moving into public service, where prior to his appointment to the PCC, he held several senior roles. Mike, welcome to Our Curious Amalgam.
Thank you, Matt, and good afternoon.
What are the PCC's three most significant accomplishments or initiatives, as you see it, in the last 12 months?
Maybe I can begin with an advocacy initiative, which is the 2025 Manila Forum for Developing Countries. This was an initiative started by the previous chairperson, and the idea was to bring together competition authorities from developing countries to discuss issues that are relevant to them. Of course, during the pandemic, they didn't hold it for 2 consecutive years, and then in 2023 and 2024, there was a new administration that came in, and so we needed time to figure out, how to go about it. But finally, we brought it back last February. We had, attendees from as far away as Kenya and the U.S. And our topic was from farm to table, the role of competition in agricultural development. So it's a welcome or maybe a refreshing departure from the usual topics that you hear, which is digital markets, AI, and the like. And it's very interesting because I think it's a very relevant issue globally. Food inflation is an issue in many countries. And so it was good to be able to gather some experts, some people in the competition arena, some people in agriculture and fisheries to talk about issues relating to agriculture.
Did you produce a report or have some common themes come out of that?
Yes, there were several themes. There's no formal report that's come out yet, but looking at issues such as cartels in the poultry industry, which apparently happens in different regions and worldwide as well. They were tackling issues on fisheries, and of course barriers to entry in several countries. Tariffs, of course, is now the hot topic, but that was partly discussed also during that forum. What was nice was you look at it. We were able to look at it from different perspectives. From the U.S. and the EU, but also from third world countries. From states in Africa and Asia, and in Asia you have the wealthier countries and the less wealthier countries. So it was a good way to understand issues and sometimes solutions that you find in other countries.
Sounds like a very interesting forum indeed. What other would you identify from the past 12 months?
There was an interesting case that we investigated. Our enforcement office does a bit of monitoring on social media, trying to see what people are talking about and, is there any relevance to competition or so. And they noticed in one, I think it was a Facebook account, that people were complaining about a practice in a mall. And, it's not just any mall, it's actually the biggest retailer in the country. They operate about 90 malls. And when you say a mall in the Philippines, you mean a really huge, not just a department store, but, it's really a huge structure with 100 plus stores and so on. But anyway, the issue had to do with this. In malls, you have the food court, where you have different stalls that sell food. But then you also have what are known as kiosks or like food carts, that you find all over the place. And the complaint was that why is it that in all these malls, when you go to any of the food carts, they only serve one brand of bottled water. And that brand of bottled water is actually produced by that mall operator or that biggest retailer. And so they did some investigation and they asked, it wasn't clear whether there was a written policy, but the vendors assumed that, they were required to, although they didn't know if anyone was ever penalized for violating that. To our surprise, the mall operator came forward and was offering to settle. This mall operator is known for being litigious, and they go to court and they often win. So it was a surprise to us. And me personally, I was a bit surprised, that, they're willing to settle. And, thinking at the back of my mind, we're just talking about bottled water, food carts. All through the process, I was thinking, it sounds too good to be true. Throughout, I was wondering, does this person have authority to actually go into that? But in any case, apparently he did. And so we hammered out a settlement with them, which was approved by the commission. they agreed that, they won't engage in this kind of behavior where, you provide a barrier to entry for other products. Interestingly, the tagline of the mall is, "We've got it all." So we kind of said, well, show everyone that you've got it all, or at least most of the products that are available for a particular line. Of course, there's the education aspect where they have to provide seminars on competition to their employees, but more than that, to their tenants. And so they're supposed to do this for at least a period of 2 years. Additionally, they're supposed to aid us in our advocacy efforts. For example, they have these LED screens, and they'll provide us, it can be like an information panel about competition and so on. Give you a bit of a background. We're a young competition agency. Our competition law was only passed in 2015, and the PCC itself was organized in 2016. So if you're looking at a culture of competition in the way that competition practitioners know it, we never really had that in the Philippines. And so not only businesses, but even people in the public, they have no idea what competition means. In fact, true story, when I got appointed, several people asked me if I was appointed to an agency that's involved in sports.
What an interesting case. And have you seen the bottled water prices go down, to your knowledge, in those malls?
The funny thing is, their bottled water is the cheapest that's being sold. They produce it themselves, and they don't really have a significant brand name. They use the name of the company with, their tag is like bonus, and so maybe they're able to keep their costs low. But to go back to that, so we do need the advocacy effort, and so they're helping us with that. But the clincher was this: they also operate movie theaters in all of their malls. And they probably have about 90 malls all over the country, and they probably have about 1,200 theaters all over the country. They offered to give us 3 30-second spots per day per movie theater for the next 2 years that we can use to promote competition. And so what we've done, of course, is we've produced videos, animated videos, and we'd have someone from our enforcement office making a spiel. And so if you watch a movie in the Philippines now, you might catch together, or maybe right before the trailers,
might see you on the screen there giving some advocacy advice at the same time.
Not me, because since I'm one of the decision makers, it won't look good if I were doing it. So we have our enforcement guys who are actually doing it, and our executive director.
Well, that sounds like you made the most of that case, and I've never seen that before with things in the movie theaters. That's amazing.
Yeah, if you go in, at least in as far as I know, in the Southeast Asian region, the competition authorities have different modes of advocacy. In Thailand, they actually have a song, and then MTV on competition, written by one of their commissioners and performed by him as well. Hong Kong produces short films, that talk about resale price maintenance. I mean, these are actual films. They're not documentaries. They create a scenario, and then, at the end you'll see, okay, what was the competition issue there, and so forth. And I think they've also done TV on that. So, we're saying, okay, this might be an interesting way if we're looking at advocating also to the public in general.
Yeah, a lot of imaginative advocacy there. Mm-hmm. What would be the third initiative or accomplishment you'd identify?
I want to talk briefly about the onion case. This is our first major cartel case. What happened was in 2023, the prices of onions skyrocketed to a point where it reached about $12 a kilo. It wasn't, it didn't get people in the streets, but obviously it caught attention of a lot of people, including our Congress. And they asked us to look into it. Congress investigated at the same time, which was very helpful because, when a congressional committee does its investigation, they're not hampered by rules that we might be hampered with. And so we were able to get some information from them. And as a result of that, we were able to conduct our first dawn raid. What happens is they went to the place, they served the inspection order, accompanied, of course, by law enforcers. Nothing eventful happened. There was token resistance by mouth only. And then once the place was secure, here now come our PCC enforcers, carrying with them photocopying machines, data capture devices. No, so it's not the typical.
So much like a dawn raid in any other jurisdiction.
Yes,
really.
Because of that raid, they were able to get copies of documents, download emails, download text messages. And here's the thing, the clincher. During the congressional hearings, these different players, under oath, said that they did not know each other. But then we were able to get all these emails and text messages showing that they were actually coordinating. And they made a case primarily for market allocation. So prices were increasing because they were allocating the market amongst themselves. It's still pending with the commission. I think it will probably be decided within this year. And after which we have to decide if the evidence is sufficient to endorse it to our Department of Justice for criminal prosecution.
Looking forward and currently, you've talked a lot about farm to table, onions, bottled water. You mentioned digital in passing, but what would you see are your enforcement priorities as an agency now and looking over the next short period?
Yeah, when we talk about priorities, of course, from the enforcer standpoint, a lot of it is, what happens during the year, what issues come up, what people might complain about. But we do have priority areas that we monitor, so that if we see that there might be a competition issue arising in one of these sectors, then, they might take an extra look. Monitoring is done primarily by our economics office. And the sectors that we look at are those that directly affect the individuals. For example, water, food and agriculture, electricity rates, so energy to that extent, transportation, health, pharmaceuticals, and the like. So anything that might have a direct impact on the consumer, on the people, those are, I would consider, priority areas that we look at. Of course, if we do receive complaints, we'd evaluate it properly. Incidentally, probably out of 100 complaints that we receive, out of every 100, maybe about only 2 pertain to competition. The 98 normally refer to consumer protection, which we don't have jurisdiction over. Yep. But we do have a referral system, so we send it to the Bureau of Consumer Protection.
It's probably not unusual for a competition agency, is it?
Yes.
So you focus on issues which affect pricing to end consumers. The PCC is obviously operating as a developing regulator. So what's the biggest challenge that you have as you advance your mission?
Well, again, as a young agency, capacity building is still something that's ongoing. And we're not complaining, though, because we've received so much assistance from international counterparts. US FTC has been very helpful, US DOJ as well. Canada had also been helpful at the start. OECD works with us. And then you go to Australia, ACCC, they've been very helpful through the years, even up to now. New Zealand as well. Japan and Korea have been constant, And so we get all this help. At the same time, we have very good relationships with our ASEAN counterparts. Singapore, of course, one of the leaders in the region, we look up to them as like a big brother or big sister. Hong Kong doesn't really have a full merger control regime, but they're very active in enforcement. And so we've actually seconded people to their office, to learn their techniques and so on. And they've also asked us for some guidance in terms of merger review if they ever get it in the future. We've also done work with Malaysia and Thailand. And the nice thing is we also try and pay it forward. So the younger agencies like Laos, Cambodia, we've also done some work with them. They're trying to benchmark as they're quite young. Cambodia's, I think, 2021. Laos, I think, is 2019. Even Malaysia, which doesn't have a merger control regime at the present, but they might finally get it this year. They've actually been with us a couple of times to try and benchmark. But capacity building is still something we have to build because we don't really have experts in competition law. We might have a couple now after so many years, but you'd be hard-pressed to find experts in competition law in the Philippines. And going with that, of course, the usual problem of government agencies is budget. We have to compete for our budget. So while we're considered an independent agency with quasi-judicial powers, at the same time, we're still dependent on both our department, the executive and the legislative, for our budget every year. And we do have constraints.
So you're probably not alone, again, in the issue of capacity and budget as a competition agency.
Yes.
Mike, we'd like to finish with a personal question, just so our listeners can understand a bit more about you. Could you tell us anything interesting or unusual that you do outside your work as the head of the Philippine agency?
Well, I've been a big basketball fan since I was, I think, 4 years old. My father used to play in commercial leagues when, of course, this was like in the 60s. So, and I used to see him in, early 70s when he was playing. And, I caught that bug. Basketball, by the way, is the most popular sport in the Philippines. Boxing is probably a close second. And so I used to play. I wasn't good enough for, the pros or anything like that, but I love the game. I love watching it. And so it's perfect that I'm here now because it's the Final Four in the NCAA, both men's and women. So it's very interesting. I do like that.
I think there are a couple of games around the corner at the Capital One Arena as well. You probably won't have time to go.
But the Wizards. Well, I don't know if there's anyone from DC here. The Wizards aren't very good right now, so might not be a good thing.
Well, that's very interesting to know about your love of basketball. So thank you very much for joining us here, and we hope that you enjoy the rest of your time at the Antitrust Spring Meeting.
Okay, thank you very much, Matt.
Hello, and welcome to Our Curious Amalgam. I'm your host, Anora Wang. Within the antitrust section, one of the best things that we can do is to meet people around the world, including enforcers who are also wonderful individuals. One of the great examples is the guest speaker I'm going to speak today. Joining me today is Commissioner Reiko Aoki, who is an economist and a commissioner of the Japan Fair Trade Commission, JFTC, since 2016. I just learned that Commissioner Aoki is also president of the Japanese Economic Association, which is an organization for professional economists. How impressive. Before joining the JFTC, Commissioner Aoki has served as an executive member of Council for Science and Technology Policy of the Japanese Cabinet Office from 2009 to 2014, and a member of the Information and Communication Council, as well as a member of the Science Council of Japan from 2014 to 2016. Welcome to the OCA program, Commissioner Aoki.
Thank you for having me again.
Yeah, our pleasure. Around this time last year, in April 2024, we got an update from you about the enforcement of JFTC. Now, a year has passed. Maybe you can give us a little bit of highlight of what the JFTC has done in the past year.
And a lot has happened in the past year, as you know. But of course, the sustaining the growth of the Japanese economy and maintaining social vitality amid long-term challenges such as declining birth rate, an aging population, and overall population decline remains to be the same challenge. And in this environment, it is essential to ensure fair and free competition. This will guarantee choices for enterprises and consumers while fostering innovation to enhance added value. And I'd like to focus on 2 points. One, digital markets, and two, challenging outdated business practices through competition policy. First, focus on digital economy. I'll talk about implementation of the Smartphone Act, an AI and generative AI-related market study. Our priority in recent years has been addressing the digital market. Like many other countries, Japan has experienced rapid social and economic changes, with digitization advancing with increasing speed, and we need to tackle competition challenges in this area with urgency. When it comes to law enforcement, we'll utilize a variety of methods to swiftly and effectively restore competition. This includes not only cease and desist orders and surcharge payment orders, but also commitment procedures, particularly in the rapidly evolving digital sector. In the digital field, April last year, the JFTC approved a commitment plan concerning a case where Google had restricted the provision of technologies on search engine and search advertising to Yahoo. And there are ongoing cases related to Google's search applications on Android devices and the investigation initiated last November regarding Amazon's marketplace. JFTC is actively utilizing opinions and information from market participants, as always, in advancing these cases. I want to highlight the Mobile Software Competition Act, which introduces ex-ante regulations for smartphone software. The JFT submitted this bill to the National Diet in April last year. It passed with overwhelming parliamentary approval in June and is set to be fully enforced by December 18th this year. The JFTC has rigorously conducted investigations and enforced Japan's main antitrust law, the Anti-Monopoly Act, in digital markets. As many competition authorities experience, however, it takes a remarkably long time, often several years, to demonstrate anti-competitive activities in individual digital market cases under the traditional framework. This has posed significant challenges. An extensive cross-ministerial market study, meanwhile, found that key software for smartphones are systematically lacking competition, with no hope for self-correction in the market. To address these dire issues, the Mobile Software Competition Act does the following. 1. Designates providers who offer specified software and conduct business exceeding a certain scale. 2. Prohibits these designated providers from engaging in certain activities that restrict competition. On March 31st, that is earlier this week, we announced the designation of regulated providers under the Act, which are currently Google and Apple. The Mobile Software Competition Act was developed through several years of initiatives led by the Cabinet Secretariat, along with a comprehensive market study by the JFTC. It is carefully designed to focus on specific digital areas, limiting its scope to software, such as smartphone operating systems. The Act clearly defines prohibited actions and compliance obligations while adopting a balanced framework that emphasizes ongoing and clear communication with the designated providers. Since before the enactment of this Act and throughout the current ongoing preparations for its implementation, we have been engaging in continuous dialogue with various stakeholders, not only with the designated providers, but also with relevant third parties, like software developers that rely on these important platforms. Aside from individual meetings, the first global forum on digital competition held at the end of January in Tokyo was notable, where we were joined by speakers from the designated providers and application developers for open discussion on how to regulate these digital spaces. Since September 2024, we have also held 9 meetings of the Study Group on Promoting Competition in Mobile Software, where experts carefully deliberate the contents of the subordinate regulation and guidelines concerning the prohibited practices, obligations for compliance, and justifiable exemptions. Perhaps most importantly, we have conducted multiple hearings with the designated providers themselves at both working and high levels as part of our effort to create fair and effective rules and ensure transparency and predictability in the enforcement of the Act. Finally, the JFTC launched its market study on generative AI in October last year, recognized both the competition-enhancing potential of innovations driven by generative AI and potential competitive risks it poses. The JFTC aims to stay abreast of the rapidly evolving market by conducting timely and comprehensive assessments. Now on to outdated business practices, in particular revision of the Subcontract Act and the Freelance Act. Business models or prevailing practice do not automatically justify legal compliance. Certain traditional practices in subcontracting relationships or in the labor market may be inconsistent with the spirit of the law, and in such cases, revisions or corrective measures are necessary. With rising costs of intermediate goods and production due to geopolitical risks and exchange rate, among other sources, wages and price of goods must be adjusted. To achieve sustainable and structural wage increase, including those for SME, small and medium enterprises, it is essential to ensure smooth price pass-through of rising costs, including labor costs, through fair transactions along with improved labor productivity. However, established relationship between a powerful downstream firm and a weaker supplier or subcontractor may prevent necessary pass-through of rising cost. There may be abuse of superior bargaining position by the downstream firm. Last year, we conducted special investigation to follow up on the guidelines on price negotiations for appropriate pass-through of labor costs, which were published in November 2023. We also worked to ensure widespread awareness of the guidelines. This year, we'll continue to strengthen our efforts by closely collaborating with relevant ministries and agencies to further promote awareness of the guidelines. In addition, we'll take strict action against cases of abuse of superior bargaining position and violation of the Subcontract Act. To establish the appropriate pass-through of costs across the entire supply chain as a new business practice, we have been collaborating with Small and Medium Business Enterprise Agency since last year to hold the study group on business transactions. This initiative has involved gathering opinions from stakeholders and conducting thorough discussions, including on revisions to the Subcontract Act. In December 24, we compiled the study's findings, and based on these results, we submitted a bill for the amendment of the subcontract to the Diet this March. We're currently facing new challenges stemming from digitalization, and a competition authority needs to address these challenges by maximizing its potential in developing new legal tools. For example, the advent of gig economy has enabled more people to choose the working styles as freelancers or self-employed workers. However, these individuals are considered undertakings rather than employees, so they are not covered by labor law. There was a public demand to ensure fair transaction of freelancers, so the Japanese government decided to submit the Freelance Act to the Diet, and it was approved. We'll continue efforts to raise awareness through public outreach activities and conduct focused investigations in industry with a high number of problematic cases. And these actions are aimed to ensure proper interaction involving freelancers through prompt and appropriate enforcement of the Act.
Or the top enforcement priority for the JFTC in the coming year be a continuity in these fronts?
Yes. Focus is digital and related issues like the rise of the gig economy is because of these apps, for instance.
We also want to, other than an update from the agency, want to get some of your insights. Perhaps you can give us some of your insight about your thinking or observation about any changes in terms of mixing competition policy with industrial policies, perhaps in Japan or in other jurisdictions.
Sure. This is a very hot issue, as you know, and because Japan has a tradition of industrial policy, and even Japan is facing a new era of relationship between industrial policy and competition policy. And it's no longer, is it industrial policy or competition policy? It's industrial policy with competition policy to complement it. And JFTC has consistently undertaken initiatives to support the business sector by enhancing predictability in competition enforcement. That's one realization of this approach. One example, as a recent advocacy initiative in the healthcare sector, we have compiled and published a casebook on generic pharmaceutical industry. In Japan, many suppliers in the generic pharmaceutical market produce each drug on a very small scale, making stable supply very difficult. To achieve the continuous and stable supply of pharmaceuticals by businesses, the use of joint ventures could be very effective. However, industry has been reluctant to pursue this option due to a vague concern that JVs aimed at achieving economies of scale may pose antitrust risk. In response, the JFTC, in cooperation with the Ministry of Health, Labor and Welfare, compiled a casebook to illustrate instances where business practices based on such needs would not raise concerns under the Anti-Monopoly Act. This initiative aims to further enhance the transparency of law enforcement and predictability for businesses. This initiative intended to prevent business from unnecessarily restraining their activities by providing clear examples of conduct that do not constitute violation in advance. In doing so, competition policy complements industrial policy in the healthcare sector by creating a market environment in which businesses can act with confidence.
That's very good observation, and thank you for pointing us to relevant documents that we should look at. We only have limited time with you, and I think the last time we learned very impressive things that you do while you are, having a little bit downtime, that you're apparently a Python coder. Is there anything that you're willing to share with us about yourself this time? Anything people would not know if they only worked with you?
But I'm a cat lover.
You're a cat lover.
Yeah, and unfortunately I can't keep cats in my house. My daughter, however, lives in New Zealand, and she returned with cats from the United States. And in New Zealand, because it doesn't have rabies, has a very strict quarantine system. Oh. So the cat was quarantined for 2 months, I think, in order to get into New Zealand.
Oh, too bad.
And despite going after this trouble, cat is also a pest in New Zealand because he kills native birds. So she has to keep her cat inside the house. So whenever I go back to New Zealand, I play with her cats intensively.
I see.
And that's something I look forward to doing every few months.
That's lovely. With that, thank you for speaking at OCA. It's a great pleasure.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust Section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.